I rise today in support of the Children Legislation Amendment Bill 2019. This bill speaks to what should be a priority for all Victorians and institutions, protecting children. It is important that this Parliament comes together and supports this legislation, and I was glad to see that those opposite this week have finally seen the writing on the wall, which the overwhelming majority of public have been in support of the changes this amendment addresses for some time. We know that one of the recommendations of the Royal Commission into institutional responses to child sexual abuse included the requirement for religious ministries to comply with the mandatory reporting to Child Protection any knowledge of sexual abuse of children to police without exception. The Commission was clear that religious confessions should no longer be exempt from that disclosure. This bill also addresses the appeal rights for serious offenders applying for a Working with Children check. This comes again from another recommendation from the Royal Commission. The recent publicity in the media surrounding this legislation has often focused on the removal of the religious confession exemption. What will have more of an impact on institutional child abuse survivors is the provisions in this legislation that mean unjust and inadequate settlements, which are the product of past limitations, could be set aside. Ensuring that religious institutions act in a manner that the public expect to protect children and young people is included in this amendment and removes the exemptions for failure to disclose offences from the Crimes Act 1958. Prohibiting individuals who have been charged with, convicted or found guilty of serious offences from appealing to VCAT for a denied Working with Children check will ensure that children are kept safe whilst freeing up time for VCAT to focus on other matters. It might not come as much of a surprise to many that I am not a religious person. The times you may find me inside a church will coincide most likely with a death or a wedding. But there is a common morality that exists in society that even non-religious people like me can relate to. There need not to be a religious text or teaching that tells us as a society that if a child or a young person is in danger, then everything possible must be done to protect that person. I acknowledge that for some that this change will be difficult to reconcile their religious beliefs with the law. But a person's religious convictions should never stand in the way of protecting anyone at risk or abuse. Society has changed and expectations on institutions' responsibilities have changed. The Royal Commission's recommendations were influenced by evidence that some in religious ministries were in positions to take action to protect children but failed to do so. It is reasonable to me that mandatory reporting for religious institutions brought into line with other professionals such as doctors, nurses, midwives, principals, teachers, police, early childhood workers, youth justice workers, out-of-home care workers and registered psychologists. If doctors and other professionals must report physical and sexual abuse without exemption, then I see no reason that religious ministers be treated differently. We must all change our practices and long-standing cultural beliefs once they become incompatible with modern expectations. This can be difficult, but is necessary. It is time that church canon law prioritise the vulnerable over dogma. The Royal Commission found that in confession, children often disclose sexual abuse suffered by them, and some clergy members disclose their abusive behaviour to deal with their own guilt. The Commission received evidence that some perpetrators admitted during confession to sexually abusing children, obtained absolution for their sins and later re-offended. Perhaps as a start, the Church can show its commitment to righting past wrongs and protecting children by creating new canon laws and guidelines that compels every child molester and abuser to do compulsory penance by reporting themselves to the police. If a Catholic priest obeying Canon Law 1367 can't automatically give absolution for a serious crime such as desecrating a Eucharist, maybe the Church should hold the protection of children at least with the same importance. I am encouraged by some other religious institutions' response to the Royal Commission, in particular the Uniting Church Synod of Victoria and Tasmania. Their Safe Church training correctly identifies the impacts of abuse for children and vulnerable people. It also puts into place guidelines and policies to deal with these issues. One thing that stood out to me whilst reading their policy was their recognition that all abuse, physical, sexual, emotional and neglect are all about misuse of power. Having the power to stop forms of abuse and choosing to not act is in itself an abuse of power. If we here in Parliament choose not to act and allow exemptions based on religion to continue, we too are guilty of abuse of the power entrusted to us when our constituents turned up at the ballot box last November. Having policies in place are are of paramount importance, and I am encouraged that the Uniting Church in their policy sets out that any person with a reasonable belief of abuse must report that abuse to the relevant authorities, and that ethical reporting ensures that the safety of a child is given greater priority than trying to avoid potential conflict. The Royal Commission's report described one case of a Catholic priest who had confessed more than 1,000 times to dozens of priests about his abuse of children. He had not been reported because his confessions were confidential. This is just not right. It's not okay. Not in today's society. This religious and cultural practice is no longer compatible with the expectations of our legal system. Legal responsibilities to protect children must take precedence. I would hope that religious ministers would prioritise a vulnerable person or a child over their personal future in that institution. Given the option of excommunication from their religion or protecting children from abuse really should be a no-brainer. If we here in this Parliament had to choose between reporting a serious crime and losing our positions as an MP, then I would be the first one up, Speaker, marching out through the door. This amendment bill also protects Victorian children in a number of other ways, one of them being by changing the Working with Children Act to limit the right of appeal to VCAT for any person who has, as an adult, been charged with, convicted of or found guilty of a Category A offence. Category A offences are the most serious offences for the purposes of the Act and are murder and attempted murder, rape and attempted rape, sexual offences committed by an adult against a child, child abuse, material offences committed by an adult, and bestiality. The Royal Commission, in its report on working with children checks, recommended that certain offenders, by virtue of the seriousness of their past conduct, should be denied any right of appeal. This amendment seeks to address this recommendation. At its core, Acting Speaker, this legislation is about protecting children. It's all about the reduction of harm. It's not about, as some have suggested, an attack on religion. The more we do to protect the children, the better we make our society. The reduction in harm naturally is an overall improvement in mental health outcomes. We know the damage that can be done to the survivors of abuse has a flow-on effect to their families, friends and wider community. Why wouldn't we act to reduce the harm? This legislation also ensures survivors of institutional child abuse are not left worse off because of the acceptance of an inadequate compensation during a period in which complex legal constraints applied, including statutory limitation periods. In 2015, the Andrews Labor government made Victoria the first jurisdiction in Australia to completely remove the statute of limitations for civil claims founded on child abuse. Before this reform, time limitations were one of the major barriers faced by victims of child abuse who wished to pursue litigation. We know that in times past our culture and society was vastly different. For those survivors in religious families, perhaps having their experiences believed would have been unfathomable. For those who were believed, we know that their stories were refused to be acknowledged by many. Once upon a time, children were seen and not heard. Today we hear them. Today their voice is loud and clear. The reforms passed in 2015 were to address this and hold to account those who used the cultural protection of the time to avoid being held to account. However, this reform did not deal with the unjust product of previous time limits, which led to survivors accepting inadequate settlements and releasing the institution from future liability by signing a deed of release. Responses and compensation were set up that spent more money on lawyers to protect institutions than what they spent on compensating survivors. It is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Acting Speaker, this legislation is good policy. It strengthens protection to protect children and seeks to allow a mechanism to right past wrongs. It is our duty to use our power in this House to reduce harm and protect children and vulnerable Victorians. I will support this legislation and I commend the bill to the House.